Judge Hussain?
You want to start, Betty?
We can start, sir.
Okay. All right. Good afternoon, everyone, and welcome back. Before I carry on, I just want to quickly deal with some questions that came in yesterday. I'll start with Sifiso Tusi, who wants to know what's the equivalent reference of Rule 37.9a and Rule 41a. There is no equivalent of a 37.9a in the magistrate's court. That's the section where a judicial officer can make the attorney or advocate pay the costs. Well, I can tell you in the magistrate's court, it's currently almost impossible to get a punitive cost order against a practitioner. Magistrates just don't do it. And of course, they don't have the inherent powers that judges have. As far as Rule 41A is concerned, there is also no equivalent except that I think the magistrates' court rules got it right. They created a panel of mediators, and a magistrate at any time during the hearing can refer the parties to a mediator to mediate the matter or to mediate on a particular point. Unfortunately, that is not, the legislation is in place, the mediators have been trained, but the Department of Justice doesn't have the funds to implement. So there is mediation, court-annexed mediation in the Magistrates' Court, or you'll see a reference of that in the Magistrates' Court Act as well. Chantel Ward wants to know, with regard to 41A6, do the parties have to make financial disclosures? The answer is if an issue arises between parties that involves finance, then financial disclosures will be made. However, to encourage parties to mediate, the rule also provides that those disclosures will not be introduced into evidence and will be kept away from the judge. So the parties can be free to mediate. She also wants to know, what if somebody can't afford mediation? Who can mediate then? Well, one of the parties should be able to mediate. By the way, just before, my view is that you shouldn't allow the question of costs. The question of costs should get in the way. When it comes to mediation, if one of the parties wants to mediate but can't afford the cost of a mediator, then I suggest the parties approach the judge, and the judge will make some sort of accommodation in terms of costs. But you are not to give up on it just because one of the parties can't afford. Well, you know, the parties are in the High Court. If you can afford to be in the High Court, surely you can afford to get a mediator to come in and save you more costs. In Cape Town, those of you who are in the Western Cape, they did a very smart thing. The High Court has gotten an understanding with a local NGO. I think they call FAMSA, the Family Association of South Africa, or something like that. They are based in Cape Town, and they deal with family law matters. So the judges in the High Court are using their services. So the parties are involved in a family dispute, they refer it for mediation to FAMSA. And they do it at a very reasonable price. It's almost a nominal price, and it works really well. And then Tato Mokhele wants to know if a matter on the urgent roll was on the urgent roll and subsequently removed, do parties still need to mediate under 41A? Now, 41A, as you saw, has a very wide definition, and it can include a dispute that is involved in an urgent application. But the nature of urgents are such that the party, the applicant, is not required to send a 41A notice because the urgency doesn't allow that. And as you know, 612 provides for condemnation for not adhering to the usual processes. So Rule 612 deals with that. However, should the matter be removed from the urgent roll, and it's now in the opposed motion roll, and the parties have been ordered to file their affidavits, then 41A will apply. But my advice to you is, in principle, you don't really need a rule to get you to go and mediate or talk settlement. As I told you yesterday, you should change your attitude, be more cooperative, less adversarial, and you won't need a rule or a judge to compel you to talk to the other side. Now, obviously, you get colleagues who are difficult and they don't cooperate and they want to be adversarial. Well, a case manager can deal with that. And I can tell you, judicial case managers do not tolerate adversarial litigation on the part of either of the parties. And please remember, if you go to court and a judge questions this, the unnecessary adversarialism, an attorney or advocate will have some difficulties getting away with it by merely saying, those were my instructions. There's advocates and attorneys are officers of the court. They owe a duty to the court, and they owe a duty not to abuse the processes of court. That's the reasoning. That's also the reasoning behind punishing lawyers for coming to court with really bad merits. Okay, let's move on to what many practitioners find to be difficult, and that is taking a set of facts and turning that into particulars of claim, or taking a set of facts and turning that into a founding affidavit. Now, the first thing is, I want to give you some practical advice. Most practitioners get into the habit, starting from their days as articled clerks or candidate attorneys or pupils, they get into the habit of running to a precedent as soon as they have something to draft. I know of firms of attorneys where the professional people will even look for a precedent for a letter. And when it comes to court processes like particulars of claim, a plea, affidavits, heads of argument even, they will go look for a precedent first. Now, if you want to be a really good lawyer, you must learn to draft without using precedents. Precedents can be helpful, but they can also cause a misdirection. Because people get careless when they use precedents, and they use them slavishly. And I've seen precedents in court where papers were issued and the attorney copied and pasted from a previous document and left the names of the previous party um, in the new particulars of claim. I mean, it's as bad as that. I've even seen attorneys use the wrong precedent. So good litigation lawyers must draft on their own. And now let me give you the good news. The good news is it can actually be done. You can draft on your own without using precedents. The only problem is there's no shortcut. It requires work, it requires application. But here's the trick. The more you draft on your own, the better you become, and you'll wean yourself off precedents completely. Now, most of you also draft commercial contracts, leases, sale of shares agreements, and partnership agreements, and so on. Well, with commercial documents, you are supposed to use a precedent because commercial documents have been developed over the years. And if you're going to draft one from start to finish, it will take too long and you will not be able to bill your client that amount. But what's happened is technology has taken over when it comes to drafting of commercial documents. You can use the most recent software. You can use document assembly systems, for example, and it's very easy to come up with the first draft. What is recommended for if you're drafting contract is for you to spend time understanding the underlying transaction and draft that carefully. For all the boilerplate clauses and so on, you can use a precedent. Because with commercial documents, most of the documents, especially all the boilerplate clauses, they're the same. But when it comes to litigation, every case is different. If you are going to use a standard form of a precedent to draft your particulars of claim and your plea, you are going to get into trouble and you'll remain a bad lawyer. So I'm going to take you through the steps you have to carry out in order to, first of all, empower yourself to draft. And that's very important. You need the skills, and you can learn those skills. Now, first thing we know is that before you draft anything, you must have obtained all the available facts. Don't draft without the facts. You start off by writing down, using numbered paragraphs, the material facts of your client's case. So you've got your client's version, you've got the witness's version, you've got all the documentation. Now write down, using numbered paragraphs, what are the main facts or material facts of what happened according to your client's version. Also, using numbered paragraph, write down what were the consequences for your client. Did your client suffer damages? Damages to what? Did your client suffer personal injury? What kind of injury? You must itemize the loss and the damage. Write that down. So you will have a list of facts. Then we're going to move on to the next step. When you've got this list of your material facts together with details of the damage, you will now understand the context of the matter. Now, one of the things you have to do as a lawyer, when you're faced with a client who has a problem, client tells you the facts. Client never tells you what area of the law is involved. A client never walks in and says, Mr. Attorney, I've got a claim in delict against Mr. X. Or, Mr. Attorney, I've got a landlord and tenant problem. The lessee doesn't want to pay the rent. You see, so what the problem is, They give you a set of facts, and the law is vast. Your job is, once you've got the facts, you must now contextualize the legal problem. So where does this lie? Is it contract? Is it dealing? Is it one of the statutory claims? You have to work out which area of the law. Because when you research the law, you can't research everything. You've got to narrow your research to what is relevant to the problem you are facing. When you do this exercise, you will know what happened and which area of the law is involved. You can recognize this is a contractual dispute, or this is defamation, or this is personal injury. You'll be able to work it out. If your knowledge of the facts is good, you'll have no difficulty in identifying the appropriate area of the law. Usually in your practice, in most practices, typically, I would say 80%, possibly more, of the problems that walk into your office will belong in one of two areas: contract or dealing. And then you have family law. So if you can draft, if you get good at drafting contractual claims, delictual claims, and family law matters, you should be able to do most of the work on your own in your practice. Now, I don't recommend that you should outsource the work. Many attorneys would brief an advocate or another attorney to draft particulars of claim. Now, number one, that doesn't help you improve your skills. But number two, each time you outsource, you're giving away 2/3 of your fees. So you're there to make money. You're there to earn a living. If you keep giving your fees away, where's the point? You become a charity or something. You have to do the work yourself. Remember, when you draft your particulars of claim, the rules require that the defendant must know what is being demanded of him and based on what cause of action. What is the reason for the demand? The next step is to research the law. Now, you can never research the law if you don't know the facts. That's putting the cart before the horse. And unfortunately, lots of practitioners do precisely that. Client tells them vaguely what the matter is about. They're in a hurry to issue a summons. They don't bother getting more facts. They rush off to a precedent, or they're going to look at a textbook, and they end up having to amend at a later stage. Now, just get one thing right. We know that the rules allow us to amend pleadings at any stage up to judgment. Even during argument, you can move an amendment. But my advice to you is that you should avoid amendments, because they end up wasting time, and very importantly, they cause wasted costs. Good lawyer will draft particulars properly first time and not have to seek an indulgence or an amendment at a later stage. Now, when you research the law, you do so after you know all the facts. Why do you research the law? Because the law will tell you what your cause of action is, and the law will assist you in formulating your cause of action. And that's exactly what I'm going to explain now. If the law says there is a remedy for your client, then the law will tell you what are the material facts that you have to prove in order to obtain that remedy. Those are the facts that the law recognizes as giving you a claim. That is the definition of a cause of action. Now, what you have to do as a practitioner is go to your list that you wrote down of your material facts and ask a simple question. Can I satisfy those requirements on the facts of my case? If the answer is yes, you're good to go. So let's see how it works. Find out what are the essential elements or ingredients or material facts. There are various ways of describing it. You can also use the old Latin phrase, facta probanda. What are the material facts? In plain language, it's the material facts for the proposed or chosen cause of action. What you do now, open another file on your computer and in numbered paragraphs, write down each of these material facts that the law says you need to prove in order to succeed. So now you will have two important lists. Firstly, a list of your client's material facts, including events, and a second list, a list of the essential facts or material facts which the law recognizes as giving you a claim. With those two lists in front of you, you now have the legal framework, and then it's up to you to start drafting. Now read through what you've got, the two lists, and here's the test. Ask these questions. Can my client's facts be sufficient to satisfy the essential elements or material facts of the cause of action? If not, then there are gaps in the version. You have to take further instructions. The next question is, if I can prove my facts in court, what does the law say is my remedy? The law will say, well, you're entitled to damages, or the law will say you're entitled to enforce the contract. The law will tell you what kind of damages you're entitled to. The third question, can I provide proof of the facts in the event that the defendant disputes them? Who will be my witnesses, and are they available? What do the documents say? Do they support my client's version, or do they contradict it? Now, one of the things that's so important for you, especially those of you who do commercial disputes, when your client gives you a version of what happened, your client will be telling you about a series of transactions. As a lawyer, be very alive to the extremely important presence of documentation. What we lawyers call contemporaneous documentation. Your client says, I delivered goods. There must be an invoice. There's got to be a delivery note. There must be proof of delivery. Where are those things? Can ask client to provide them. Your client says, I have a tenant that's not paying rent. Well, there must have been an agreement. Do you have an agreement of lease? Can I have a copy? Did you send this tenant a notice? Can I see that? So the contemporaneous documentation is very important because they are crucial for you to prove your case in court. So a good lawyer at this early stage, now remember what you have, two lists of facts. One, the facts that make up your client's version. Two, the facts which the law tells you that you need to prove in order to succeed in getting the relief that you want or the remedy. Now you have to ask yourself, if I've got a cause of action, how will I prove those facts? You see, the material facts, or the fakta probanda as we call it, the onus will be on the plaintiff to provide proof of those facts on a balance of probabilities. As a good lawyer, you're going to say, at this early stage, do I have proof of those facts? Can I prove them? Who will be my witnesses? What documents will I need? Do the documents and the witnesses support my client's version of what happened? And of course, if your client gave you a version that's improbable, you won't even get this far. You're going to tell client, listen, that's rubbish. Judge is not going to accept it. You're going to do better than that. So once you've answered these questions, you've now come to a point where you've established the cause of action. These two lists represent the facts that the law recognizes as giving your client a claim. Now, I suggest you go and get this book, Practical Drafting Skills. It will tell you how to draft pleadings and affidavits, opinions and heads without using precedents, okay? Now, the particulars of claim. A warning, if you get this wrong from the start, you are in trouble before you start, for a number of reasons. If you get the cause of action wrong and you end up going to trial, you will pay a price the minute you call your first witness, because your witness will give a version which does not support the cause of action. You're in serious trouble. You will have to now ask for a postponement, you'll have to amend, and so on. However, as a strategy, it's a very bad idea to keep amending your particulars of claim. It is a bad idea to amend the material facts that you already pleaded. And the reason is quite clear. If you bring an application to amend, you'll be allowed to amend. Judges want the parties to canvass all the issues and will be only too ready to allow you to amend. But there's one problem. If you're amending the material facts of your case, and once the amendment is approved and your particulars are amended, your particulars of claim before the amendment still exist. They are still there. They're in the court file. You'll find them on case lines if you're in Gauteng. In other words, they're still there. And guess what happens under cross-examination? Your opponent is looking at what you drafted initially. The witness is now giving a different version, which is compatible with your particulars as amended. And now your opponent says to your client who's in the witness box, did you tell your attorney the following? And your opponent will read from the particulars pre-amendment. So now your opponent is going to be reading a different version to this client. And the next question is, you told your attorney this. Now that's what I call, for a plaintiff, it's a lose-lose question. Because if client says, no, I didn't tell my attorney that, well, no one believes him. Because everyone knows attorneys only draft from instructions. Advocates only draft from instructions. So what they drafted must have come from the client's instruction. The next question is, you have contradicted that version. You can't explain the contradiction. So what happens? Your witness got discredited. Why? Not because the witness is lying, but you discredited the witness by drafting poorly, using a precedent, and then your client, your lay client, who is now in the witness box for the first time, contradicts it. So you see how much damage you can do with amendments. So get it right first, up front. You must draft particulars that firstly sets out a cause of action, and secondly sets out the material facts of your client's version, not of a version you got out of a precedent. If you act for a defendant, you must answer the substance of the plaintiff's claim. Bare denials don't assist. You will have to set out a defense based on your client's version. Now, you can go and read pleadings in the High Court. What you'll see are two things. The one plea which says, ad paragraph 4, the allegations are noted. Now, that's absolute rubbish. It's not in the rules. You can't say allegations are noted. Where do you think attorneys get this from? I've seen advocates draft this too. Where does it come from? It comes from precedents. Some fool wrote, the allegations are noted. Now all the other fools are copying and pasting it. If you ever write the allegations are noted, a judge will treat it as an admission. Then there's the other favorite, everyone's favorite. The allegations are denied as if specifically traversed, and plaintiff is put to the proof thereof. It's in every precedent. It's a bare denial. If you say, I deny as if specifically traversed, it means you are denying every allegation in that paragraph. There's nothing wrong with that if you can then give an explanation. You must be able to say why you're denying it. What I'm telling you is that if you act for a defendant and you deny a fact, you must say, or you must provide the basis in fact and or law for the denial. Otherwise, it's a bare denial. It's illegal. A good lawyer, defendant's lawyer, will plead the case in the new method. It's in the book, Practical Drafting Skills, but this is how it works. Traditionally, and even to this day, many defendants' lawyers plead the traditional way. They'll go, ad paragraph 1 to 2, the allegations are admitted. Ad paragraph 3 to 4, the allegations are denied for the following reasons, and so on they go. What happens there is that the judge has to read through the whole plea to work out what is the defense. You see, judges, when they read particulars of claim, they're looking for two things. They're checking to see if there is a cause of action, and they're checking on the facts. They want to see what's the version. Having satisfied themselves with those two things, the judges are very keen to see if there's a defense, because now they're convinced plaintiff has a case. But now the next question is, does the defendant have an answer? Now, obviously, if you're going to simply deny or put in bare denials, the judge gets the wrong impression. The judge thinks, well, this defendant is just wasting time. He has no defense. And I can promise you, when the judge walks into court, before the plaintiff can even start with the opening statement, a good judge will say to the plaintiff's lawyers, sit down, I want to talk to your opponent. And then they'll ask you, do you have a defense? And if you do have a defense, what is it and why didn't you plead it? You never get out of that one. You're going to lose the case. So when you draft a plea, a very good idea is to deal with the formal requirements. Plaintiff is defendant, go add 1 and 2 allegations are admitted. And then you start a new paragraph. You say the defendant's answer or the defendant's defense. And in one paragraph, state all the facts which give you a defense to the plaintiff's claim in one go. And then you go add paragraph 3, and you'll say, for reasons stated in 2 above, the allegations are denied. So what happens for the rest of your document? You're going to deal with each paragraph, but you'll simply plead it according to what's in paragraph 2, where you set out all your full defense. Judges love it. It's persuasive. It tells the judge you are willing to disclose your defense. The judge will see that you have a defense. And in fact, judges don't bother to read beyond that paragraph. They can see you've got a defense. That's the best way to plead. But let me give you the bad news. The bad news is you can only plead like that if your client has a defense. If your client hasn't got a defense or an answer or a viable defense or a discernible defense, well, you can't plead like that. Then you must do it the old-fashioned way and make a great pretense of having a defense. Well, I can tell you, judges don't fall for it. They can read it. They can see there's no defense. You're just messing around. Well, what if you don't have a defense, as often happens? Then you've got Rule 41A. Then you say to client, look here, we're not going to mess around with this thing. You don't have a response. Let's call the other side and see if we can't settle it. That's what you're going to do. Then there's this thing here. The duty to begin. When you draft particulars of claim or even a plea, always apply your mind to the question of onus and the duty to begin. They are two different things. The onus always remains with the plaintiff. He who alleges must prove. Plaintiff will bear the onus of proving their material facts on a balance of probabilities. If they fail, that ends the matter, they fail. But the duty to begin is often determined by the pleadings. You see, the onus never shifts from the plaintiff, but the duty to begin usually stays with the party that bears the onus. That would be the plaintiff. But the pleadings might determine that the defendant, based on their plea, will bear the duty to begin. So the onus stays with the plaintiff, duty to begin shifts to the defendant. Now, I'll give you an example of that. Plaintiff sues on a suretyship. Defendant admits the signature, but puts up a new set of facts which provide a defense. The defendant says, I signed the document under duress, and then pleads what the duress was and so on. In that case, when you get to trial, plaintiff comes to court, in opening statement states, the Lord, here's the original suretyship. May I hand it up? The defendant admits his signature. I rest my case. Sit down. The defendant has the duty to begin in order to prove the duress. The plaintiff then rebuts. That's what happens. So as plaintiff, the burden of proof will remain on you, but the duty to begin can shift. Now, if you plead as a defendant, try and try not to plead in such a way that you attract the duty to begin. However, you will be in a situation where it's not possible to do that. For example, when with a suretyship or any commercial document, like an acknowledgement of debt, once you admit the signature, then you're going to attract the duty to begin to prove your defense. Now, drafting pleadings is an essential skill. If you can't draft pleadings, you are really going to be a dysfunctional lawyer, because it's that skill which you will use throughout the whole process. You know, if you can draft particulars of claim well, drafting affidavits going to be no problem. You'll be able to draft heads of argument. Easy. That's where the skill comes from. And like any other skill, you get really good at it the more you practice. What I mean by that is when clients give you instruction, draft on your own. You've got colleagues who can check your draft, or if you want, draft on your own and then take out the office precedent and see if you've got it right. I can assure you, the more you draft on your own, the less you will rely on a precedent, the better a lawyer you will be. Those of you who want to succeed, go and practice, draft on your own. When you've drafted on your own, go and hand it to a colleague and say, can you read this for me and tell me if it's okay? The colleague might read it and show you where it's gone wrong and help you to fix it and things like that. You know, for years, I mean, I'm talking decades, attorneys briefed advocates to do the drafting, the particulars of claim. And often, you know, I practiced at the bar for over 20 years. And I can tell you, sometimes I got a brief to draft something that is so simple that I called up the attorney and I said, is this a joke? Do you really want me to draft this? Yes, I want you to draft it and send it to me. The most extreme example, I once had an attorney who sent me a brief, you know, the blue covers and a ribbon and everything. What was in it? Could you please draft a notice of set down for me in this matter? You know, I thought this was a joke. But that's how bad it becomes if you don't write or draft on your own. You just get worse, okay? So use the method. I seriously recommend, and I'm not trying to sell you my book. It's been prescribed by the Legal Practice Council. Many of you probably have it already. It's very popular. Follow the steps. Tells you how to do this. All you have to do after that is learn how to state the material facts that come from your client's version. Okay. Now, let's move on to the next phase. Post pleadings. Pleadings have closed. Now, before I get there, we have not perfected case management yet. We will get there. Eventually, we will get there. If you look at what happens in the UK or in Canada or in Australia, as soon as pleadings closed, in other words, particulars of claim, plea. By the way, even here in Gauteng, we case manage the filing of a plea. This business of the defendant waiting way past the time to file, then he waits for a notice of bar, then he files on the last day, all that nonsense has to stop. As a defendant, you know, when you get the summons, you enter appearance to defend, you know, diarize the date when you have to file the plea. Because now we're going to introduce a system where the registrar will automatically flag that date, and if the plea has not been filed, a notice goes out. There's no notice of bar and so on. And then plaintiffs' lawyers, they're also slack. The time comes and goes, they don't do anything. Months can go by and the plea is not filed. You have to stop that. What happens under good case management, the plea is always filed on time. The court system ensures that it does. You don't rely on the lawyers to remind each other to file pleadings or to serve notices to compel and notices of bar. The system does it. But the most important step is that if you're in the UK, the file goes to the case manager. Now, in the other Commonwealth countries, they use a full-time case manager who handles all the case management. He's in the court building, he's got his own staff, and does all the work. Here, we wanted to use the same model, but the Department of Justice is still trying to work out when and how they're going to appoint case managers. So what happened here is that the judges got fed up of waiting, and they are case managing the matter. So potentially there's a conflict because we have adversarial judges, not inquisitorial judges. So what happens then is that the case managing judge then does not hear the trial. And it works perfectly. There's nothing wrong with that system. But the point I want to make is that as soon as pleadings close, the file is with the case manager. The case manager calls the lawyers in. Plaintiff's lawyer, defendant's lawyer, sit down. Let's go through the pleadings. Plaintiff, this is a little bit vague. I'm not sure what you mean by this. Will you go and amend it? Defendant, I see you pleaded bare denials here. Do you have a defense? Can you tell me what your defense is? And why didn't you plead it? Okay, I'll give you some time to amend. I'll give you 7 days to amend the plea. Now, can you imagine what happens after that first case conference with the manager, judicial manager? Something like 80% of those cases get settled after the first case conference with the judicial manager. Simple as that. That is why matters can be finalized in Canada within 3 months, in the UK within 6 months, in the US within 6 and 9 months. That's where we want to go, but first get us electricity and a registrar who knows how to read. So anyway, we've just got chaos in our registrar's offices. So the point to be made, when pleadings closed, don't sit back and think, well, now I'm going to do discoveries and experts and all of that stuff. Do your job. Sit down, read your particulars of claim if you're plaintiff, read the plea that is filed by the defendant, and see if there is a defense pleaded by the defendant. If there's no defense or if it's vague, you may want to apply for summary judgment. That's the new rule. And it works brilliantly, by the way. If there's a problem with the defendant's plea, don't take exception and all of that stuff. Bring interlocutories and so on. It just wastes time and money. Call your opponent. Say, listen, But, this plea of yours is excipiable. Can you please fix it? And by the way, let's meet and see if we can't settle this matter. That's what you should be doing. But here is some steps that you should be taking. How do the pleadings impact on your case concept? Case concept is what happened according to your client's version. The case concept guides you through your case, but it might require adjustment based on what the parties have pleaded. Do you need to adjust your case concept? What facts have become undisputed? And do these undisputed facts support your case? Or does it support your opponent's case? Which of your material facts have become disputed? You need to make a note of that because you will have to provide proof of those facts as the plaintiff. You have to carry out a proof analysis. Take each material fact and now say, how will I provide proof of that fact? Who will be my witness? What document will I need? What visual evidence will I need? Do I have all that? A proof analysis is absolutely vital at an early stage. Now look at the plea. Does it disclose a defense? And if so, what is the defense? Can your client provide an answer to it? What does your client say about this defense? At this stage, now you have a plea, you should update your chronology document. Remember, I told you, you start writing a chronology document at the beginning. Finally, and most importantly, can you identify the issues between the parties? You've got the particulars, you've got the plea. What is the issue? What are the issues as they arise out of the pleadings? Write it down. You know, lawyers have this bad habit. They read superficially and they think, I know what this is. But you ask them to write it down, see what happens. And this was quite funny, actually. In Johannesburg, in the case management court, we created a form that the parties had to fill in so that the case managing judge can see that all the formalities have been dealt with and that the matter is indeed ready for trial. One of the paragraphs in that form was, please state the triable issues between the parties. And there was a space there for you to fill in. Well, the attorneys got really smart. Do you know what they filled in? They said, refer to pleadings. Clever, eh? Because we all know pleadings are there to define the issues, so they don't refer to pleadings. Of course, the pleadings are unhelpful because it's precedent rubbish. So now the judges had to amend that form. Then the form read, the parties are to state the triable issues without reference to the pleadings. So they have to write it down. Do you know how the lawyers struggled with that? They really struggled because they've never applied their minds to that. They just pleaded precedents and bare denials, and now they want to go to trial. Well, this is a very crucial step. Once pleadings close, that's the first thing a judge will ask. Have you had a discussion about this matter? And have you agreed on what the triable issue or issues are? Now, the trick is for you and your opponent to meet without the judge or any case manager. Between yourselves, get together and agree on what the issue is. You have to do this as soon as pleadings close. I'll tell you why. Because depending on what you agree as being the issues, you'll then deal with discoveries and experts and so on. All the pre-hearing processes will be dictated by these issues. How on earth will you know a document that your client brought is relevant and should go into the bundle if you don't know what the issues are? Because the question is, to what issue is this document relevant? You can't just simply put everything into enormous bundles, call it bundle A and bundle B and hand it to the judge. Those days are gone. Okay. Where you have an opponent who does not cooperate, will not come to a meeting, then write a letter to the judge president to say, I've got this opponent who is not willing to cooperate. Can you appoint a judge to case manage? Now you will get somewhere. Okay. So we're going to deal with discovery. Discovery and what we call these days e-discovery must be dealt with. When you've identified the issues, you have to identify the documents required in order for you to prove your facts. The defendant does the same thing. The defendant sees what the issues are. There are certain facts that the defendant will have to prove. What are the documents that assist my case? Our courts do not encourage wide discovery. We all know that is a criminal waste of costs, and judges will penalize you. If you handed up the judge 4 lever arch files, and if you use 2 pages, the judge will disallow you the costs of putting together the bundle and the discovery. Now, on contemporaneous documentation, I already mentioned this. You must be a smart lawyer. When you're consulting with clients, be alive to the fact that there may or may not be contemporaneous documentation. Where you see that there has to be a document, or there must be a document, or the transaction is such that you expect there to be documents, talk to client. It is not always the case that clients will come to you with the documents. Our courts no longer tolerate opposed interlocutory applications regarding discovery. Disputes around production of documents, proof of documents, these have to be resolved between the parties in case conferences. This is nothing new. If you go way back and you look at the Rule 37 pre-trial conferences, one of the items on the agenda is always the bundle of discovered documents, the trial bundle, and the status of the documents in the trial bundle. You are supposed to come to agreement. If you can't agree on a document for whatever reason, then go to the case manager. If you think that your opponent is being unnecessarily difficult and should be admitting this document, put it on the agenda for the case manager and deal with it there. And a judge can make a ruling in chambers. You don't have to go to court. Now, this is very important. I told you yesterday, please go and read the ECT Act. You are meant to understand how electronic documents are produced, how they are accessed, how do you preserve them, and how do you present them in court. You know, in the good old days when a document was printed and then someone signed it by hand and in ink, and that was the original. That doesn't happen anymore. Documents are produced electronically all the time. There are electronic signatures that get used. There are special electronic signatures. You must know how to deal with it. E-discovery is the retrieval of materials originating from a computer, and it extends beyond computer files to encompass the analysis, gathering, processing, review, and production of discovery materials in electronic format from start to finish. The basic principle is that information which is stored, used, or transmitted in an electronic form should be available through discovery with the same openness as traditional forms. Now, I'll tell you what, the method of producing document has changed, but the rules regarding the admission of documents and the rules regarding discovery have not changed. They are still the same. So things like proportionality, relevance still apply to electronic documents. But electronic documents are very different. They are not, if you don't know, if you don't understand how they are produced, you will struggle. Um, I'll give you a stupid example, okay, of just how bad things are in this country. I was in Bloemfontein. Um, being a silk, I have to go there from time to time. It's my punishment, you see. So, during apartheid, you couldn't go anywhere in the country without first going through bloody Bloemfontein. So now we still have to end up going there. So, well, I was in Bloemfontein with one of my seminars, and as usual, I get attorneys coming to me during tea time and lunchtime looking for some free advice. But this attorney came up with something that I found quite amusing. He came to me and he said, listen, I've got a problem. It's in a magistrate's court. I said, yeah, what's the problem? He said, well, he had instructions from a client to sue a defendant for goods sold and delivered. The defendant did not defend, and he applied for judgment by default. Now, in the Magistrate's Court, you apply in writing, you've got to file certain documents and so on. And there's someone who sits there in a dingy office and then stamps it granted and sends it back to you. Well, if they don't grant it, they send you a letter stating why they didn't grant it. So he got this letter refusing judgment. And the query was, you did not file the original invoice. So the invoice has the proof of sale, and the Magi wanted the original invoice. So now that invoice was produced on a computer. So what's an original? Now this attorney didn't know how to deal with it. So now I started explaining to him how you go about proving that document that you printed off the hard drive is a true reflection of the original, and how you do this by consulting the metadata on your computer and using the metadata to prove that this invoice is authentic. So I was going through this, and then the attorney starts looking at me quite distressed. So I said, hold on, you've got a problem with all of this? He said, yes. And then I realized what the problem was. How on earth was he now going to explain all this to a magistrate in Bloemfontein, even if he finds a sober one? So he said, now what do I do? I said, okay, easy. I told him, asked him, do you have a printing shop, a stationery shop in Bloem? He said, yes. I said, go there, buy a rubber stamp that says original. Bring the stamp to your office, take the same invoice that the magistrate returned, stamp it, and send it back. He did that. He called me some weeks later and said, hey, I got judgment. So you see, that's how ridiculous it is in this country. But I must warn you, those of you who do commercial work, or those of you involved in commercial fraud cases, please learn how to manage electronic documents. There's a reference there to a book that was co-written by Terry Harrison and myself. Terry Harrison is an English solicitor, and he's an expert on e-discovery, and did a lot of work in the UK and the United States on e-discovery. And it's a small booklet. You could read it in one sitting, but it gives you a very good guide. Okay. Now let's deal with case conferences. I've mentioned this many times already. You are not to avoid case conferences to start with. You should encourage your staff, yourself, your opponents to hold case conferences. And look, it's not a problem these days. You don't have to drive across town and find parking and all of that nonsense. You just do it on Teams or a Zoom meeting. You can have a conference with your opponent, okay? You are not to underestimate the value of case conferences. You know, if you can't resolve the case or settle the case, at least you can resolve a number of issues. Things like proof of documentation. You can say, you can go to a case conference, for example, and say, look here, will you admit this invoice? They say no. Okay, here's the metadata. We're making the metadata available to you. You can see from the metadata that that is the original document. Okay, now do you admit it? No, we don't. Okay, will you please place on record your reasons for not admitting it? It's got to be in the minutes. And I want to warn you that at the hearing, we will lead evidence to prove this document. We will lead evidence of the metadata. If you do not dispute my witness, we will ask for a punitive cost order. That's what you do, because you will have an opponent who has no basis for disputing the document, but will just be difficult, adversarial, non-cooperative. You must prove it. Don't let them get away with it. When someone says, I do not admit that, you say, okay, we'll note that you are not admitting it. Now we need to note why you're not admitting it. And that's got to be in the minutes. So you are encouraged to cooperate with your opponent and attend case conferences. They will also be called by judicial case managers. Now there, the good thing about a judicial case conference under judicial case management is that your opponent can't mess you around. When they get that letter to say, come to the conference, they have to be there. They can't say, no, I'm not available or anything like that. They just have to be there. When you attend case conference, you are expected to actually achieve the purpose, not merely comply. So when you attend with a judge, I suggest you do the following. Number one, prepare an agenda. The judge will expect you to have an agenda for him. The judge will also include items from him or herself for the agenda. Give your opponent the agenda and say, can he add his items or can we remove some? You will then settle the agenda between yourself and your opponent. But here comes the most important part. I always recommend that you hold a case conference with your opponent first before you go to the judge. So you arrange a case conference with your opponent where you'll have the same agenda in front of you, and then you deal with it. See if you can reach agreement, minute those agreements before you go to the judge. Now, if you get to the judge and you say, well, judge, we've settled these points, here's a minute, the judge will be very happy. The judge will say, right, you guys have done good work here. Let's see how else we can facilitate this matter. And there's a warning on the screen. Read Rule 37.9a. Judges will penalize lawyers for failing to cooperate. And as I told you, for many years, for decades, we never used this rule. Judges didn't punish colleagues or the practitioners. That has changed. Okay. So what do you expect? Focus on what you believe to be the main tribal issues between the parties. That's rule number one. Though once pleadings closed, focus on the tribal issues. It may not emerge from the pleadings because the pleadings are drafted badly. A good habit is for you to write down separately, without referring to the pleadings, what you believe are the tribal issues. This is exactly what a judicial case manager will want. Then a crucial step, be prepared to reduce the number of issues. First define the issues, then work out which issues will be resolutive of the whole case. So let's say there are 4 issues. But when you analyze the issues, you realize that issue number 3, if that's resolved in your favor, then it disposes of the whole case. What judges want is for you to say to them, this is the issue that needs determination. You need not deal with the other 3. It reduces the work, judges appreciate it, and you put this in your minutes of your case conferences. And most importantly, when you get a trial date, you are still obliged to send the judge a practice note. You have to write a practice note, by the way. I think it's a week prior to the trial date. In that practice note, you can say, there are, of the 4 issues, the court need only resolve number 3. It is resolutive of the whole matter. Because you pleaded issues doesn't mean the judge has to resolve them, each of them. Your opponent should similarly write down what they believe are the material issues. One of the purposes of pretrial conferencing or case conferencing is to make admissions of fact that are not material to the issues. I say a good lawyer will write down these facts where they are not really material to the main issues. They are not resolutive of the issue. The other party should make admissions. I say you demand admissions. A very good strategy is for you to request admissions of fact in writing, send it to your opponent at least 2 weeks before you meet. The reason for that is if you go to a pretrial conference or a case conference, and there for the first time you say to your opponent, will you make these admissions? What do you think your opponent will do? He'll say, I'll have to take instructions and revert, which means you've just wasted time. Whereas if you sent it 2 weeks in advance, your opponent gets an opportunity to take instructions and will be ready to deal with it. And as I said, if your opponent refuses to make admissions which you know they should make, place on record that an order will be sought from the case managing judge. The whole idea is to reach agreement without having to resort to orders for compelling. In other words, reach agreement over documentation, the admission of documentation without having to bring interlocutory applications. In preparation for trial, it is in your Rule 37 directives for pretrial conferences. Those of you who are not from Gauteng, I seriously recommend that you should go to the Gauteng practice directives and find in there, it was actually drafted in Johannesburg by our then Deputy Judge President. He drafted an agenda for pretrial conferences. And he said, these are the things you must deal with. And there are 13 of those things. It makes a perfect template for you to use, and you can use it as a tick box and see that you can comply with all of that, okay? What judges do not want and you will get into trouble if you don't deal with it properly. In the middle of a trial, you say to your witness, Mr. X, take a look at document number 15 in bundle A in front of you. So he looks, and your opponent stands up and says, objection, my lord. We do not admit this document. My learned friend will have to prove its authenticity. The first question the judge will say, but hold on. Have you not discussed this in a pre-trial conference? Did you not discuss this in a case conference? Did you not try to reach agreement? Show me in the minutes where you did this. And if you didn't, you'll be in trouble. Now, obviously, there are documents where you have to provide proof. In fact, those are the kind of documents which form part of your cause of action, like a suretyship agreement or an acknowledgement of debt or a lease agreement. Those documents will be the cause of action, and then you'll have to provide proof of that. But there are other documents, things like invoices, receipts, delivery notes. They need to be, there's no basis to dispute those things unless you genuinely believe a delivery note was forged. Then you must plead it. Then you must state it in your refusal to admit. Okay. So cooperation and a sensible approach is required. You can see that an adversarial approach doesn't really work anymore. The parties must agree on what goes into the trial bundle, having agreed to keep the documents that will require proof to the barest minimum. This has to be a very small bundle, seriously small. Be ready to discuss where appropriate the calling of expert witnesses. This has to be dealt with in a pre-trial conference or case conference. You must look at the practice directives. This is managed now in most of our courts. What happened is that Gauteng started managing experts and found that they were saving a lot of time and expense. Then the other courts in the country saw the benefit of this, and they all 9 provinces are now case managing experts. Judges require experts to agree insofar as they can and confine the dispute to a narrow point. This must be reflected in the joint minutes of the experts. Experts, according to the practice directives, they must meet, and hear this, in the absence of attorneys. They must meet on their own somewhere, or they can do it on the phone or on a Teams meeting. They must discuss their respective views, reach agreement. Our experience was that if you allowed attorneys to attend this meeting, then nothing was agreed. Because, attorneys, everything is without prejudice. Our rights, our clients' rights are reserved in toto. Have you seen attorneys write that in their letters? Our rights are reserved in toto. They don't even know what it bloody means. They copied it from a precedent. And then the next line is, we trust the above is in order. I know some of you are laughing because you are writing this in your letters. Just stop it, okay? Be good lawyers. Now, experts, their reports and the joint minutes are usually enough to suffice. They rarely ever disagree. I mean, can you imagine 2 experts, let's say 2 orthopedic surgeons. They got the same training. They both went to the same university, wrote the same exams, practiced as orthopedic surgeons. What are the chances they will disagree with each other? Disagreements with experts, and just remember this, it's a practical tip. When experts disagree, the disagreement is caused by a difference in the facts that are given to them. If you give 2 experts exactly the same facts, they'll come up with the same opinion. Good lawyers, if they see the experts are disagreeing, go and look at what they were briefed with. What were the facts given to the expert? Now, there's where the problem comes in, because the experts receive the facts from the attorneys, from the clients, and they give facts that they think will manipulate the expert into giving them the outcome that they want. But it all gets unraveled under cross-examination, and two good experts will realize they've been manipulated, and they'll reach agreement and file their report. You don't have to call the experts then. In Gauteng, and I know in other provinces, you will be refused trial certification if the experts have not met and filed a joint minute. Okay. So before you attend a pre-trial conference or even a case conference, I told you prepare an agenda and get the agenda to a judge. I also told you meet before you go to see the judge, reach as many agreements as you can. Judges appreciate it. Very important, always keep accurate minutes of the meeting. Now there's a question I get asked all the time. Must we record it? No, you don't need. There's no requirement that it must be recorded. In the past, it was a big mission to record a pre-trial conference. We didn't have digital technology. You had to bring one of those big machines into the room, and there were loads of cables and microphones and so on. It was just too costly and too much of a mission. These days, you can record very easily on your cell phone, or you can buy a recording instrument, digital recorder, with Dragon software on it, so that it will even produce a written version for you, or a transcript. Cheap, easy to get. My advice to you is that in any matter of substance, please record, but do it openly. Put the machine in the middle of the table and say, can we agree to record? I found this works brilliantly, because there's nothing like a recording to stop the lawyers from talking rubbish. Okay. Once they know it's being recorded, they'll stick to the agenda. They'll answer the questions. They'll be relevant. The meeting will be quicker, and you'll get somewhere. Just try running these meetings without recording and see what happens. Right. Now, let's deal with this thing called post-certification. You've now been through all the processes, and you are now in a position to go to trial. Go to trial means you can go to court, 10 o'clock, your witness is waiting, sitting in court, waiting to be called, and you are ready to make your opening statement. That means trial ready. Now, when you are ready for trial, what I've prepared is a checklist I want you to go through. Again, number one on the checklist, focus on the main issues as agreed between the parties, because this determines relevance. When you lead evidence in court in order to prove a material fact or facts, the rule for every lawyer, remember from yesterday, the first rule is that the witness's evidence must be relevant. Relevant to what? Relevant to an issue. What does relevance mean? It means that this evidence will be of assistance to the judge to resolve the dispute. Second rule, the evidence must be admissible in its form. Third rule, I call it the dirty dog rule. The version must be likely to have happened. If you've got 3 yeses right there, you can call your witness. That is what is meant by trial ready. You must, before you go to trial now, review your case concept and chronology document. If you're a good lawyer and you've been writing as you went along, you kept the lists, all you have to do is amend them or adjust them. Now you have to carry out a fact analysis. I don't have time to deal with this in detail. By the way, let me see if I can find this thing. There's a book here. It's the only book of its kind. If you don't have it, you're a litigation lawyer, you must get it. It's called Trial Advocacy, The Art of Persuasion. It deals with all of this in much more detail. It tells you what to do step by step, and you really can't go wrong. You just have to work hard. Carry out fact analysis, proof analysis. You see, a fact analysis will tell you what are the material facts that you have to prove in order to succeed. Proof analysis tells you how you are going to prove those facts. Who will be the witness? What documents will I need? That's the proof analysis. Then you have to carry out a witness analysis. Who are the witnesses that will be testifying? You must have a list of witnesses. You must also rank your witnesses. Remember, it's a rule. And please don't get anyone to change your mind. You always start with your best witness. If your best witness is not there, then stand the matter down. Tell the judge there's a problem. The witness hasn't arrived. Now, very often the judge will say, oh, well, don't you have another witness we can start with in the meantime? No. Usually, Murphy's Law, your worst witness, the one that you call to court, just in case the other one doesn't turn out, they're there from 7 in the morning. But your main witness, your best witness might be late. I told you, good lawyer keeps track of all the witnesses, and 2 days before the trial at least, you are going to contact the witnesses, find out where they are, see that they have transport, arrange for them to be in court. That's what a good lawyer does. Witnesses in this country, oh my God, it's ridiculous. I mean, it's anything and everything can go wrong. A taxi strike, load shedding, an accident, it never ends. And I wrote it right at the end there, not as a tick box point, but a reminder that even at this stage, you must consider settlement, okay? I mentioned that the issues, you must have a clear picture of what the issue is. You must write it down, and you will present this to the judge in the opening statement. Now, with those courts in the country that have proper case management, this will not be necessary because the judge would have read the minutes of the case conferences or pre-trial conference, and the judge would see there that the parties agreed that these are the issues. The judge might just walk into court and just confirm with you that these are the issues. For a judge, that is crucial. No judge can start a trial without being firmly focused on the issues, because that's what the judge needs to decide in order to resolve the dispute. The issues, as defined, must be compatible with your case concept. What happened? The issues must be compatible. Can you, on the facts of your case, say that the issues represent what happened between the parties, and your client's version will persuade the judge to decide in your favor? Then you have to look at the legal requirements to establish your claim or defense. That's part of your proof analysis, witness analysis, and your analysis of the documentation. The question is, what facts support or prove those requirements? Your cause of action will set out your material facts. Those are the material facts which define the issues. You'll need to work out what do you have to prove and how will you prove in order to discharge the onus. So this is a brief description of fact analysis. I'm going to give you a short break of 10 minutes now, and I'm going to get to this after the break, okay? Um, so take a break, 10 minutes, all right? All right, let's get started. There are two questions I want to deal with very quickly before we carry on. The first is from Simone Sarah. She says, she wants me to explain this really persuasive method of pleading to particulars of claim. Now, I seriously recommend, Simone, that you get this book, Practical Drafting Skills. It's all in there. But quickly, in a nutshell, instead of dissipating your defense through your whole plea by mentioning parts of it as you respond to each paragraph of plaintiff's particulars of claim, the best method, instead of doing that, is to state your defense. The you must state your defense and state all the facts that support that defense. So what happens effectively, the judge reads your defense in one go, one paragraph. You can divide it into sub-paragraphs, but that's it. The judge sees the defense. But as I told you, if you actually have a defense, that's a way to do it. Okay? If you don't have a defense, then you shouldn't be there in the first place. The second question is that what happens if opposition is unwilling to attend a conference and they always have an excuse the day before and so on? Sizwe, let me assure you that that is exactly what happens. Attorneys don't turn up, or they'll phone you the last minute. Or I've even have cases where they just never showed up, and you try phoning them, they don't answer the phone. Simple. You write a letter to the judge, if you've got a judge, a case managing judge allocated to you. If you don't have one allocated, you're going to now use this as a motivation to have a judge appointed. You will write the letter to the judge president, which is the letter of motivation. But if you already have a judge allocated, write to the judge to say, you arranged conferences, these are the dates, they refuse to attend, or whatever the attorney from the other side has done. You are now requesting a case conference with the judge, and that the judge must now send out an invitation to the other side. You will also then give the judge an agenda, which you're going to use at that hearing, at conference. What you should do is, you want to be cooperative, you want to be less adversarial, but don't allow your opponent to take advantage of this. So they are still out there, these attorneys who just don't cooperate at all. You wonder if they are even practicing as an attorney. You can never get hold of them. And there are many of those. What I can tell you, though, is judges take a very dim view of that kind of conduct. When they see it, they will punish those lawyers. Okay, let's go to fact analysis briefly, because this is so important for you. Make a note of the material facts that you will have to prove, bearing in mind the issues and the onus. Now let's look at a list of things you can do. Write down the material facts that are undisputed or admitted, or where your opponent has no basis for disputing them. This is really an exercise that you have to do if you are going into a trial. What you want is to write down those facts that are undisputed, because they are common cause, or they are admitted. But in this list, you must also add those facts which your opponent disputes. They say, I deny it, but they don't tell you why they deny it. So it's a bare denial. You put it into this category. The most important reason for this is when you analyze the undisputed facts, a good lawyer will say, do these facts support my client's version of what happened? If the answer is yes, you've got a good case. If the answer is no, you've got a problem. That's the one reason you need that list. But there's a second reason. It is a highly effective weapon when you're cross-examining. Because when you've got a list of undisputed facts, you just put the leading question under cross-examination. And because they're undisputed, your witness will keep saying yes. You put the question, leading question, you admit you were driving on Thabo Mbeki Street, yes. It's not in dispute the robots were working, yes. So your version starts looking good. The witnesses are agreeing with you. That's how important this list is. Then write down those facts that are disputed and that you have to prove to discharge the onus. When you've got those facts written down, now you write down the witnesses you need to prove those facts. Make a list of those facts which support your version. That's disputed and undisputed. Make a list of those facts that support your version. Make a list of facts that don't support your version. You know, if this is a genuine dispute and it goes to court, there will be facts which don't support your version. You must be alive to them. Make a list of the undisputed facts that support your version. Note, you do this so that you can present the facts to the judge, who will make a finding of fact that favors your case. Let's deal with witness analysis. Look at the lists that we've written already. Now work out who will provide the evidence to present your client's version of what actually happened. Make a list of witnesses, and next to each name, write down the main facts that this witness will present. Now, this is something you would have done in your witness analysis, okay? Ask if you are able to call these witnesses. You have to deal with the question of sufficiency of evidence. You probably came across this at university. Sufficiency means, will this witness provide me with sufficient evidence in order to prove a fact so that I may discharge the onus? Now do what I call the sensible thing. Establish with client if the witness is available and willing to come to court without a subpoena. If you get this wrong, you are heading for an expensive disaster. This is such a simple thing. The lawyers get it wrong all the time. They take it for granted that this witness will turn up. Client tells you, no, he'll be there. Okay. And then they don't show up. And there's a million excuses. Now, you cannot believe the number of cases I've seen being postponed at the cost of the plaintiff or the defendant where the witnesses did not show up. Now you're in serious trouble. And if this has happened previously, the judge might decide to refuse you a postponement. And now what you're going to do? You're going to lose the case. Okay. Now, handling witnesses is absolutely crucial. And I'm going to spend some time on this because we underestimate this. We think people will come to court and they're going to take the witness stand and they're going to be brilliant and we'll win the case. Well, it doesn't work like that. You have to do your job as a lawyer. So let's see what happens. You need a statement from each witness, which you took down in a chronological sequence. I told you, witnesses don't tell you a story in a sequence. They just give you a whole story. Your job is to sit back, listen, and then write down, say to the witness, let's start again. But this time, I'm going to write the statement down from beginning to ending, step by step. In other words, you will write it sequentially. Then you will prepare a chronology document from the statement. This is a one-pager. It must not be more than one page. One pager that says material fact, time. Material fact, time. And it must be in a sequence. Then you must have a document where you write down the order in which you will call the witnesses. That's very important. It's part of your witness analysis. Who are your witnesses? Now rank them in the order in which you will call them. Most important, best witness first. Remember, all the witnesses must be relevant. The one thing judges hate is if you call a witness and the witness is irrelevant. That really gets them riled up, and you will get some snide remarks from the bench. You might even get reprimanded from the bench. You see it all the time in court. A witness is testifying for 20 minutes, and then the judge looks up and says to the counsel, Mr. Smith, why did you call this witness? What the judge is saying is, I don't see the relevance. I really don't. Why did you call this witness? You will have a list of witnesses in the order in which you will call them in the trial. Remember to call the witness. When you call a witness, I've mentioned this already. Do the test, must be relevant, must be admissible, must be probable. If you get that wrong and you call a witness who fails one of those three tests, you are in for an expensive debacle. That's all, okay? And this is something that you might think is really unnecessary for me to tell you. Establish at an early stage which witnesses require an interpreter and book the interpreter in time. I've spent the last 42 years of my life in courtrooms all over the country and even outside the country. This interpreter, if he's not there or she's not there, you cannot move. The trial hasn't gone anywhere. And this can be an expensive waste of costs. So be careful about that. And you need to find the right witness, okay? In this country with so many different languages, we're a multilingual society. You need to find the right a right interpreter. And you need to find someone who will make sure he's there at 10 o'clock in the morning or quarter to 10. You don't want to run around looking for the interpreter when the judge's registrar comes in and says, are you ready? Can I call the judge? Okay, now then let's look at the undisputed facts again. I told you this is very important. You see, as a lawyer in a trial, it's only natural for you to focus squarely on the disputed facts. And so you should. But a good lawyer will also pay a good deal of attention on the undisputed facts because it helps your strategy. It is very useful in persuading the judge to find in your favor. And the technique is to make a list of the material undisputed facts. Include in this list those facts your opponent disputes but has no basis for the dispute. Now, why do you need this? The undisputed facts are important in obtaining a successful outcome. Why? Firstly, because they assist you in determining the probabilities. It assists the judge to determine the probabilities. Judges use them all the time. Remember, I told you, the judge doesn't have to work out what is the truth. The judge needs to work out what is likely to have happened. They are absolutely essential in resolving factual disputes, the undisputed facts. Yesterday, I mentioned the Plascon test. That test is actually based on the undisputed facts between the parties. Many people don't realize it, but go and read that. It's used in opposed motions. Where there is a dispute of fact, it is the undisputed facts that help to determine which party's version is probable and therefore more persuasive. That's what a judge does. That's how a judge tests it. You must measure the probabilities of your client's version against the framework of the undisputed facts. If the undisputed facts support your client's version, you're good to go. If the undisputed facts don't support your client's version, you're in trouble. Why are you in trouble? Because this is a test that the judge will apply. But as I say, don't dwell too much on the undisputed facts. Concentrate on proving your version of the disputed facts. Focus on the disputed facts and marshal witnesses and exhibits which support your client's version of the disputed facts. I've mentioned if the undisputed facts don't support your client's version, you're in trouble, because what it indicates is that your client's version may be improbable. Or worse, the judge might find your client's version to be improbable. Now, here's a checklist for witnesses. Managing witnesses, as I told you, is key to succeeding in a trial. We went through this already. The witness must be relevant to an issue or issues, must be admissible, the version to be presented must be likely to have happened, it must be probable, it must be supported by the undisputed facts. Then you have to ask, does the witness testify from personal knowledge? Very often, this undermines the witness's testimony. The best witness is the witness who testifies from personal knowledge. A good example of such a witness is the eyewitness, someone who saw what happened and can reliably tell the judge what he saw or she saw. Check if your witness had opportunity to observe an incident and then to reliably give an account of it to the judge. It's called reliability. Very importantly, can you support your witness with contemporary documents which you discovered? Can you support your witness with supporting evidence, corroboration if necessary? There are some witnesses that require corroboration simply because there's a rule against self-corroboration. You can't call a witness to say, well, where were you? Well, I was sitting at home watching television. How can you prove that? Well, I was alone, and I can tell you I was watching television. You need someone to corroborate. And then check if it's possible that your witness could be mistaken. Mistake has a habit of creeping up at the worst time when they testify. Did you check for any possible bias? You could slip up with this so easily. If a witness has an interest in the outcome of the case, that witness suffers from a bias. Once that comes out in court, and it usually does, the witness is discredited, okay? Is there some motive to testify which can possibly discredit your witness? Is the witness's version supported by the undisputed facts? Is the version contradicted by any undisputed facts? Now let's look at a preparation checklist before you proceed to lead a witness in court. See if you've done the following. I like these checklists. You'll see in my books, I always give you checklists. And I know there are many firms of attorneys that use these checklists. They copy it from my book and they laminate it on a piece of paper. They laminate it and they put it on the desk and they use it as a checklist. We can go through this quickly because you're familiar with it. Do you have a proof analysis? Where is this witness ranked in order of importance? Did you prepare a chronology document? Did you hand a chronology document to the witness and explain you will lead accordingly? Did your witness have access to the written statement? Did your witness have time to read the statement? Were you able to select the documents you will introduce through this witness, and did you flag them in the bundle? You know, judges hate it when you say to the witness, take a look at the document in front of you, and the witness is looking, can't find it. What document? Don't you have a bundle in front of you? No. Oh, sorry. I beg your pardon. Here's the bundle. Go to page 15. Now, that is so, I don't know why lawyers do this. It's so unprofessional. The bundle must be already in the witness box. It must be open to the page that of the first document you're going to refer to. If there's going to be another document, you must flag it. Okay, tell the witness before they take the stand, the document will be open, the next document is flagged in green or red or whatever. Okay? Has the witness been through witness briefing? This is something South African lawyers are really bad at. They are terrible. Witness briefing, in my opinion, must be made compulsory. If you look at the United States, Canada, UK, Australia, where they use jury trials, witness briefing is absolutely essential. They do not miss doing witness briefing. Every witness that they call will be put through briefing. What is witness briefing? Well, witnesses, people you call to court, lay people, they do not see courtrooms as being happy places or user-friendly places. They all believe that courtrooms are where you go to get into trouble. They don't like coming to court. They hate it. But worst of all, they'll be nervous about it. They've never been to court before. They don't know what to do. Now, that's the job of the lawyer. The lawyer sees to it that the witness is taken to court either early that same morning or on another day before the trial. And you say to the witness, this is the courtroom, come inside, let me walk you through. And you show the witness the layout, where the judge sits, where the lawyers sit. You're going to tell the witness, this is the witness box, get in there, stand there, see what it feels like. There'll be people sitting in the gallery. This thing in front of you is recording what you're saying. It's a microphone. And explain the process, how you will ask questions, how the witness must speak in the direction of the judge in an audible voice. All of those things you must explain to them. If you are going to be using an interpreter, explain how the interpreter does the swearing in. So when the witness is called, the witness will still be nervous, but you would have managed the anxiety. They now know what to do. they will make a better impression. Now, in jury trials, demeanor is very, very important. Those people sitting in the jury are all lay people. They watch the witness, and they are influenced by the way the witness behaves in the witness box when being led and being cross-examined. But in our courts, we're very fortunate that we have only judge-only trials. We don't use juries. Judges who are professional lawyers know that if a witness does badly in the witness box, it doesn't necessarily mean they're being dishonest. Poor demeanor might be a symptom of nervousness. However, we have two kinds of judges here. The one kind that doesn't care two hoots for demeanor because they know it's not a reflection of whether the witness is honest or not, or reliable or not. But you get judges who do place importance on it. And they will watch the witness. They will make notes about what they see. And they'll comment about the demeanor in the judgment, and they will make findings about it. Okay, it might influence them to disbelieve the witness, or it might influence them to accept that witness. You don't take a chance. You don't know what kind of judge you get. So do the witness briefing. Like I said, you will not eliminate the nervousness, but at least you'll manage it, okay? By the way, in case you didn't know, in our criminal courts, especially in all the big cities, the Department of Justice has appointed what are called court preparation officers. Court preparation officers. They do witness briefing in criminal cases, and they concentrate on cases involving children, gender-based violence, things like that. It's a very good development. I did not check to see how it works, but it's there. In the civil courts, that job is yours. You have to carry out witness briefing. Do the next checklist. Do you have a thorough knowledge of all the available facts and know where the witness fits into your case concept? That's very important, okay? You have prepared a document with the main facts for the witness, arranged in a sequence, which you will use as quick reference on your feet. Now, I'll tell you how this works. It works really well, and I think you should use the technique. I told you, prepare a chronology document for the witness. It's the main facts that the witness will give you in a sequence. How does this assist you? It assists you to control the witness. I will show you how to do this when later when I deal with leading witnesses. You lead your witness according to the facts as they appear sequentially on your chronology document. That does two things. Firstly, the version will come out sequentially, which makes it easier for the judge to understand and to digest. Secondly, it helps you to control the witness. And it helps you to lead all the main evidence or the material facts so that you don't forget. You know, this happens all the time. We're all humans. You're leading a witness, you're on your feet, you're under pressure, and you forget to lead an important fact. You forgot. It's in the witness's statement. And then guess what happens? Under cross-examination, your opponent will say, "Did you tell your attorney this?" "Yes, I told him." "Well, he didn't lead it. You just made that up." The witness is being damaged. So it's important to use a chronology document. I'll show you later an effective method. you must satisfy yourself that the witness's evidence that you will lead does not fall foul of the rules of evidence. So you must do the test: relevant, admissible, probable. That's the most important test. Then you're going to deal with hearsay. The rules against against admission, evidence, character, lay opinion, improperly obtained evidence. You deal with all of that. Now, here's a warning: never overtry a case. Do not even be tempted. On each material fact, you need one credible witness. If your first witness went off well, don't call the next witness on the same fact set. The judge will get very irritated. I'll tell you what judges don't like. It doesn't matter which court they're in or what kind of matter. Judges don't like it when the matter takes too long. They want the matter to be quick. It must be short. You must be short. You must sit down. If you keep it short, you'll do well. But if you run the trial, if you overtry it, you call the third witness on the same fact set, you will irritate the judge. I've been through witness briefing already. You can read it. It's comprehensively dealt with in my book, okay? Now, let's deal with another very important piece of strategy, and that is drafting heads of argument. This is crucial, absolutely crucial. I'll tell you why. These days, we are appointing more judges who are not silks. They are not experienced. We are having attorneys appointed as judges who have never been in a trial themselves, but they become judges. They don't have the experience. These days, judges do not give extempore judgments. Even in the simplest matter, they'll reserve. When you have a judge who is likely to reserve, please make sure you've written heads of argument, because it assists the judge later when they sit down to write the judgment. They will reference the heads of argument. It's very important. But I'll tell you what heads of argument are most useful for. There is nothing like heads of argument to prepare you, the lawyer, for the trial. A good set of heads is indispensable. Your case concept is clear to you. You know what the issues are. You know where the onus lies. You know what the witnesses are going to say. I say that you should draft heads of argument before you go to trial. When you're preparing already, prepare heads of argument. Now, there are many lawyers, and you can read it. There are a number of books that deal with this. Will say that you should begin to draft heads at the point when you're drafting particulars of claim. And then you improve those heads as you go along. And by the time you get to trial, you already have a draft heads in your bag. My advice to you is make sure before you get to court on day one of the trial that you've got draft heads in your bag. All you have to do is listen to the evidence, see how it goes. It's so easy these days. You've got your laptop. During a break, you update your heads. And by the time an argument comes, you can say to the judge, "My lord, I have heads of argument. May I hand it up?" Judges love it. They will thank you for it because it assists them. Okay. Also, if you got heads of argument before you get to trial, it helps you to run the whole trial, because you are now going to run your trial according to your heads of argument. And that works very effectively. So trials are unpredictable. Something goes wrong. A witness that you thought was great turned out to be rubbish. So you will amend your heads. Okay? Remember the rule: heads must be short. Short, sharp, to the point, done. Lengthy heads don't work. For God's sake, don't give the judge 100 pages of heads. You know that judges in our highest courts, SCA and Constitutional Court, they have issued rules and directives limiting the number of pages of your heads, because it's a requirement to file heads. In the SCA, you are given 40 pages, and that is typing on one side of the page, double spacing, and you must use the whole page. That's 40 pages. In the Constitutional Court, where you file written argument instead of heads of argument, you are given 50 pages, not more. If you want more, you have to apply in writing to the judge, president, or the chief justice for permission to file longer heads. The trick is to write short heads. Okay. You must never copy and paste into your heads. If you have to refer to judgments, which is where you will refer to judgments, is in your head. If you are referring to judgments, then do not copy and paste from law reports or textbooks. Read the judgment, then make the point you want to make in your own words, in your heads, then give the judge the reference and the paragraph number. When you scroll, and then paste into your heads, judges hate it. By the way, in the SCA and the Constitutional Court, there's a directive against it. If you copy and paste from authorities, they will disallow your costs or even punish you. Then we have this thing called a virtual hearing. It comes from the COVID era. And in case you didn't know, we are still in the COVID era. Virtual hearings are actually here to stay. And my advice to you is, if you are in a virtual hearing, whether it's a trial or an opposed motion, you must prepare heads of argument. Okay? Heads. Look, virtual hearings are, of course, well suited to things like opposed applications, reviews, and appeals. But they are also used for trials. My advice to you is that if you're expecting your matter to be dealt with in a virtual hearing, prepare excellent heads. Not good heads, excellent heads. The reason being that in a in-person hearing, you have the advantage of talking directly to the judge, and you can make a more persuasive presentation than you would on a little screen. I mean, in a virtual hearing, the judge sees what you are seeing now. You're seeing head and shoulders only, and it's very difficult to concentrate on a screen. That is why this course is over 2 days and not on 1 day. Judges in virtual hearings will read and rely on the papers. Your heads take on a higher importance than ever before. Your pleadings and affidavits must disclose a sound cause of action and must be supported by a version that is probable. We've been through that a few times. Now let's move on to the trial. First, Let me remind you that you are still obliged to settle the matter if you can, or settle issues, some of the issues if you can. Now, on the day of the trial, you need to find out if your matter has been allocated. By the way, how matters are set down for trial differs from one province to the other. They really do. I don't have the time to deal with 9 provinces. So I'm going to deal with it generally. My advice to you is please read the practice directives, especially if you're an attorney or a Section 34 advocate, because you will be responsible for setting the matter down. There are formalities, there are directives. You must know what they are, you must know how to comply with them. Of course, on the day you introduce yourself to the judge, see that your first and second witnesses are there waiting outside. See that the interpreter and the stenographer are there. Did you notice, those of you who go to trial a lot, that matters get delayed either because one of these 2 characters are not there. The stenographer disappeared, no one knows where she is, or the interpreter. And yet, when you walked into court, they were there. But then when the registrar says, can I call the judge? And you look, they're not there. Then you say, no, the stenographer is not there. Now they go looking for her. It's just ridiculous. You must start on time. Judges hate delay, and they hate it even more when you request that the matter should stand down for some reason. I mean, when judges walk into court, they sit down, they want to hear the trial. They don't want to hear you standing up and say, well, my lord, could the matter stand down for this reason? They get irritated. Always check if the bundles are available. The copy is in the witness box. Okay. I've written an entire chapter on how to prepare yourself before the judge walks in. So go and read the book. Now we come to the opening statement. Now, this is not a trial advocacy program. I'm going to just give you some practical suggestions. Judges hate lengthy opening statements. Seriously, they'll stop you and say, listen, I think you should call your first witness. Keep it short and to the point. The judge will read the papers before coming into court. These days, we train judges to read the papers before they come to court. Now you know why you have to draft really well. If your pleadings are terribly poor, bad drafting, the judge already has a poor impression of you even before they got to the court. When you get to your feet, tell the judge what the case is about so the judge understands the nature of the dispute, and then tell the judge what the issues are. Hand up to the judge a chronology document that you prepared for purposes of the trial. Judges love it, they find it helpful. Also, you must be ready to tell the judge your estimated duration of the hearing. You see, you would have done that in the pre-trial conference, but that estimate may have changed while you prepared for trial. Admissions may have been made. You may not be calling some witnesses now. The estimate has changed. Now tell the judge how you intend to run the case. Give details of the witnesses you will call and in what order. Tell them why you're calling each witness. Then you must deal with the logistics. See to it that the judge has the bundles, the minutes of the case conferences, and be ready to deal with queries, and then call your first witness. Your first witness will have been through witness briefing. So the witness walks confidently straight to the witness box, takes the oath, and there's no delay. Now, let's deal with evidence in chief. Many trial lawyers will tell you this is one of the most difficult things to do. But if you prepared well and you use the right technique, it's not a problem. The first rule, I call this the first rule. The judge wants to hear the evidence from the mouth of the witness. The judge doesn't want to hear the evidence from you. What this means is that you are not to ask leading questions in chief. If you ask leading questions, you are simply going to discredit your witness and you'll also discredit yourself. There's a rule against asking leading questions in chief. And the reason is very simple. Judges want to hear what happened from the mouths of the witness, not from the mouth of the lawyer. You must keep in mind your case concept and where the witness fits in. You must have a copy of the chronology document for the witness before you start leading. It must be there in front of you. You see, one of the advantage of a chronology document, if you have problems reading small writing, I suggest you prepare a chronology document for yourself using large font so that you can keep this document in front of you, either on a lectern or even on the desk in front of you, and you can lead the witness. Now, when you lead a witness in chief, you want to keep eye contact with the witness. And when the witness is answering, you want to keep eye contact with the judge. What you don't want to do is read questions from a piece of paper. When you ask questions while looking at a statement, the witness doesn't like it because you are not making contact with the witness. You will run into difficulties. Judges hate it when, instead of concentrating on the witness, you are standing there writing notes. They find it disruptive and will hold you up for it. When you ask a question, look at the judge. You want to involve the judge as you want to involve the witness. The judge must feel like he or she is important. Judges hate it when you ignore them. And that can happen when you're leading a witness in chief. You're busy engaging into a nice conversation with your witness, you forgot there's a judge there until the judge reminds you. And they have all different ways of reminding you. They'll say something like, Mr. Smith, could you slow down, please? I need to write this down. Okay. Or Mr. Smith, can you speak up, please? I can't hear you. They're being irritable. Why? Because you didn't keep them involved. When a witness answers a question, eye contact with the judge. Okay? Always lead the facts in a sequence. You would have prepared the witness to do so. You would have handed a chronology document to the witness. Always lead sequentially. Then there's re-examination after cross-examination. The first rule of re-examination is don't re-examine. Re-examination is there only for you to deal with a possible confusion or a gap in the evidence. Re-examination is not there for you to try and fill in the cracks that appeared during cross-examination. Okay, and if you are engaged in a lengthy re-examination, I can tell you, you're probably going to lose the case. Okay, a very well-prepared lawyer will hardly find the need to re-examine. When the judge says re-examination, you say, I have no questions, my lord, and sit down very confidently. That's what you want to do. If your first witness performs well, don't call supporting witnesses, okay? Tell them to go home. Thank you very much. You must remain aware of your list of witnesses, your witness analysis, when you have the evidence you need. When you've got what you need, close confidently. Now, one of the things that irritates, and please don't do this, you've called your witness. The witness has now finished testifying. The judge will just look up at you and say, yes, Mr. Smith. What he's saying is, call your next witness or close your case. The last thing judges want to hear is, my Lord, can I have a short adjournment? I just need to take instructions or something like that. That makes a poor impression. The judge gets fed up. Now he's got to go back to his chambers, maybe 5 floors up. The lifts are not working. It's South Africa. So they get irritated with you. Good lawyer knows when the witness is done. Witness steps down. You stand up and then you say, my Lord, I call my next witness. It's Mr. Jones. But if you are not calling any further witnesses, you must be very confident in saying, my Lord, that is the plaintiff's case, sit down. No asking for short adjournments and so on. Sit down. Now, let's look at some technique when it comes to leading a witness in chief. I'm going to give you some pointers. This is something you will do much better if you went to a trial advocacy course. So these are the things that you should do. Firstly, do not ask leading questions. Now, leading questions are allowed, but you are only allowed to ask a leading question where the facts that come out are agreed or undisputed. And even then, you must first check with your opponent and say, listen, would you mind if I led my witness on these facts? Because asking a leading question saves time. For example, the witness's occupation and address, that's not in dispute. So instead of saying, where do you work? What is your job? Where do you reside? What is your address? A leading question is so much more convenient. Mr. Smith, you work for Checkers as a driver and you reside in Diepkloof. Yes, done. You see, undisputed, it'll be allowed. Now, the technique is first to ask permission of your opponent, and then before you ask the leading questions, tell the judge, my Lord, I'm going to be leading this witness. My learned friend has no objection. And then you ask the leading questions. But when you come to the disputed facts, you dare not ask leading questions. Use simple questions and plain language. Use short sentences. Use the active voice. Okay? Please don't try and show off your vocabulary. I don't know what's wrong with these lawyers who are extremely verbose. They use big words, complex language. I don't know who they're trying to impress. The fools in the gallery, who cares if they impress? The judge will not be impressed. The witness will not understand you. Stick to plain language. The technique is for you to always think of the answer you want first. Don't ask the question if you don't know what answer you want. Because first think of the answer you want, then bring out the answer through the use of non-leading questions. When you lead a witness in chief, always set the scene first. In other words, qualify the witness. You were there. Where were you? What were you doing? Where were you standing? And so on. Then use the headlining method and ask transitional questions. You must tell the witness where you are going. In other words, you give a headline. Mr. Smith, I'm going to ask you about an incident that took place on the 7th of July, 2022. Okay? Or I'm going to ask you about your employment. I now want to ask you to apply your mind to the events that took place on Friday night. Okay? Now, that's not leading. You're saying to the witness, this is what I'm going to ask you. Now you ask non-leading questions to bring out the facts. Now, that does two things. One, it tells the witness what to expect and makes the witness easy to handle. And by the way, if you are smart, you will have the chronology document and you will have the main facts in a sequence. Use those main facts to create a heading. The next technique is what we call piggybacking or looping, where you ask your next question from the answer to the previous question. So in other words, you piggyback on the answer to formulate your next question. Why do we use that technique? Because then you're not leading the witness. So if the witness says, I work at Checkers, what work do you do at Checkers? I am a driver. What kind of vehicle do you drive? Do you see, I'm asking the next question from the answer to the previous question. Then you will not be leading. Always use a sequence. Diagrams, sketches, photographs, visual evidence is highly persuasive. Judges like to see a photograph or a map because it clarifies things for them. They can see it. It's visual evidence. They don't have to rely on a description from another person. So they can see it. Never lose the opportunity to use visual evidence. Like you're setting the scene, have an aerial photograph that you downloaded from Google and you discovered it. There may be objects like a weapon or a contract. Take a look at this. Whose signature is that? Visual evidence, highly persuasive. Make sure you use it. When you consult with the witness in preparation for the trial, take the witness through the visual evidence. You must, throughout the process, control the witness. You don't want the witness to go off on their own. Now, there's a technique that some lawyers use, which is absolutely nonsense. It's this technique. They'll say, Mr. Smith, where were you on such and such a date? So Smith says where he was. Then the next question is, tell the court what happened. So Mr. Smith starts talking. Then he stops talking. Then the lawyer looks up and says, and then what happened? Or what happened next? You've lost control. This witness is just going to talk. They're not sure what you want. They don't know in which direction to go. They don't understand the sequencing, nothing. You've lost control. Avoid that. By using a sequence, headline, piggybacking, that method will help you to control the witness. Avoid multifaceted questions. It must be one question, one answer. If you ask questions that require 3 answers, you will be making a mistake because witnesses generally, remember, they were a bit nervous now. They're in the witness box. They've never done this before. They'll answer one of the 3 questions and leave out the other 2. And of course, your opponent will be alive to this and then say in argument, my lord, the witness refused to answer the question. My learned friend asked a question, the witness refused to answer it. But actually, the witness had an answer. You asked it incorrectly. Avoid open-ended questions like, and then what happened? Or tell the court what happened. Okay? What did you see? Never appear to lose confidence in your own witness. That happens all the time. where the witness gives you the wrong answer. And that happens to every one of us. You'll ask a question, you'll get an answer you didn't expect. You know, I always tell lawyers, trial lawyers, that there's a lot of acting that goes on. You need to have, if you didn't study drama, if you don't know how to act, well, then go and learn. If you get the wrong answer, you're supposed to look like that's exactly what you were waiting for, and then smoothly move off to the next question. But if you give the game away, like some lawyers do, they get the wrong answer, then they look up into the ceiling, or they throw their pen down and they glare at the witness. The judge knows it went wrong, your opponent knows it went wrong, you're in trouble. Never be antagonistic towards your own witness. It doesn't matter how much they irritate you. You have to be polite and you have to be professional. Note that the facts and the applicable law must support your case. That's just a reminder. Now, what I'm going to do now is take you through how judges test or evaluate witnesses. Remember, I told you the reasoning, hear the evidence, hear the witness, evaluate the witness, make findings of fact, draw inferences from those facts. That's how it's done, okay? You know that now. Establish the credibility of your witness. Lead the relevant background information. Show that this witness has personal knowledge. Lead evidence that will strengthen the witness. Deal with things like opportunity to observe. How far were you? Oh, you were 2 meters away. How do you know the defendant's driver? Oh, I know him. He lives in my neighborhood. Okay. Bring out that there's no bias. And so you're strengthening your witness by doing that. And you must never be boring. For God's sake, there are some lawyers that are so boring, it's amazing the judge doesn't fall asleep immediately. Don't lead your witness in a boring monotone, okay? Some people do have boring monotones. It's natural for them. They speak like that. Now, if you're one of those people who speak in a boring monotone, for God's sake, go and have elocution lessons. You can be trained to get out of the boring monotone, okay? You can actually be trained. The first chapter of my book was not written by me. It was written by a voice expert, okay? And there's an entire chapter devoted to voice. That's so important. Your voice, your articulation is most important in a trial. I can assure you, if you are before a jury and you use a boring monotone, the whole lot of them will be asleep and they won't be listening to you. Not ever again, okay? So use your voice, raise the tone, lower the tone, use the dramatic effect, okay? Instead of saying to the judge, saying to the witness, tell the judge what happened. No, that doesn't work. Mr. Smith, I'm sure his lordship would like to hear that. Tell his lordship what happened. You see, that, and then you make eye contact with the judge. That's a good lawyer, okay? You must never appear to be disinterested in your own witness. And I've seen this in court so often. What happens? The witness is asked to explain something, and while the witness is explaining, what's the lawyer doing? Busy writing some notes or talking to his colleague here sitting next to him, or shuffling through the papers. Then the witness stops talking, and then you look up and say, oh, and then what happened? Bad lawyer. You know what the witness is going to say. You are bored with it. It is boring, but you are to look very interested, okay? You must keep eye contact and you must look like you're interested in what your witness is saying. Because you know what? If you're disinterested, why should the judge listen? I mean, who cares? You want to hold the attention of the judge through the whole hearing. Always keep the the witness the evidence relevant and interesting. And now we come to cross-examination. Again, I'm going to give you some advice. This is not trial advocacy. The first rule of cross-examination: never ask a question if you don't already know the answer. Rule number one: if you don't know, don't ask. The second rule is you must know when not to cross-examine. When a witness completes the evidence in chief, and there's no reason for you to cross-examine, the witness did not damage your case, the witness did not present any facts that harm your case, don't cross-examine. There are some lawyers who think, oh, well, they must cross-examine, and then they end up doing more damage. If the witness doesn't hurt you, you should stand up, look super confident, look across at your opponent, and then look at the judge and say, well, my lord, if that's the evidence in chief, I have no questions for this witness, and sit down. You've done two things. You told the judge this witness is of no use, and secondly, you didn't waste the judge's time. The judge will be persuaded by you. It's a simple technique, use it. The purpose of cross-examination is to bring out evidence or facts that suit your case. Therefore, if your opponent's witness doesn't damage your case, sit down. Okay. Now, let's look at some of the purposes of cross-examination. You want to elicit facts from your opponent's witness that's favorable to your case. That works brilliantly. If you can get concessions from your opponent's witness that can be admitted into evidence, you can always say to the judge, my lord, on the defendant's own version, this is what happened. Highly persuasive. You want to challenge the truth and accuracy of the witness's version. You want to discredit the witness. You want to introduce your client's version to the witness and give the witness an opportunity to comment. Now, this is what we generally call putting your version to the witness. If in a criminal case, if you fail to do this, it's fatal. But in a civil case, it's not so fatal, okay? But it's always a good idea where there's a dispute of fact to put your client's version to the witness, okay? Now, again, be very careful how you do this. It depends on the kind of witness you're cross-examining. If you're cross-examining a strong witness, and you know that more cross-examination will strengthen this witness, you want to keep the cross-examination short and to the point. When it comes to putting the version, you do that right at the end, okay? Where you put the version as briefly and as vaguely as possible, and you say, the plaintiff denies that he said that, and before the witness can answer, you say, that's the evidence, my lord, and sit down. Okay? You see, you need to be a bit of an actor. You can also undermine witnesses who are still to testify. Now, you know your opponent has lined up other witnesses, and you know what they're going to say. This one has already contradicted that witness, and you can say, listen, you saw Mr. X outside? Yes. You traveled together? Yes. Mr. X he says the following. That's not what you said. So you're busy discrediting the other witness. And then you want to parade your own case. What does that mean? When you're putting the leading questions, you are telling the witness what you want the witness to say. You are leading the witness. You want the witness merely to agree with you. You end up parading your case. Now, if you go through all these purposes of cross-examination, there's one thing you will not see. It is not the purpose of cross-examination to break the witness. You only see that in the movies, on television, where the witness is reduced to a nervous wreck that has to be carried out of court on a stretcher. That doesn't happen. You are not to be rude, adversarial, aggressive towards any witness, not even your opponent's witnesses. I'll tell you what judges hate the most. Judges hate it when you badger a witness during cross-examination. They will stop you and they'll make you look bad. So here are some pointers. If it is not necessary to cross-examine, don't. If the witness does not damage your case and cannot assist your case, sit down. Ask yourself whether you have any effective ammunition to use during cross-examination. If the answer is no, and the witness is credible, don't cross-examine. Don't think you're going to go on a fishing expedition that usually ends badly. If you do cross-examine, keep your questions relevant, keep it short, and remember, only leading questions. The one thing that you should never do, and I see lawyers do this all the time, and it is so bloody stupid. Please don't get the witness to repeat the evidence in chief. It serves no purpose. It merely strengthens the witness's credibility. The judge gets bored because he's heard all this already. Don't say to the witness, tell his lordship what happened. But that is exactly what that is exactly sorry, I lost my train of thought there because of these messages on the screen. Don't ask the witness under cross-examination, tell his lordship what you saw. But that's the same question your opponent asked in chief. The witness is just going to repeat the same thing. You see, some lawyers think if you get the witness to repeat what was said in chief, they'll make a mistake. And then you can go, aha, contradiction, and cross-examine. I promise you, it doesn't happen like that. Never repeat it. Now, here's some tips. Make an assessment of the witness. Is this a good witness or a bad one? If you see this is a strong witness, intelligent, gets to the point, impressive, you may not want to cross-examine. Always listen to the witness's answers. When you lead and when your opponent is leading and when you are cross-examining, focus on the answer. Never argue with the witness. There are some witnesses who will try and bait you. They want you to get argumentative, then they'll control you. Police officers are good at this. Never fall for that trick. Always remain unmoved when faced with the unexpected. I dealt with that. Never badger the witness. You are not there to break the witness. Never breach the rules of evidence. Because if you do, your opponent will say objection. Judge will say upheld, and you look like a fool. Always remember your purpose, your main purpose of cross-examination is to bring out the facts that suit your case concept. Always ask the leading questions. Now, here's a method. Always bring out facts, not conclusions. This is a big mistake. Don't ask the witness for a conclusion. Just bring out the facts. Where does the conclusion come in? When you present argument. You'll say to the judge, these are the facts. The only conclusion your lordship can draw is the following. Now, don't under cross-examination expect to get that conclusion from the witness, because you will not. One fact, one question. Use simple language, simple sentences. Never be ambiguous or confusing. Think before you ask. Your choice of words are important. precise language. Never allow the witness to explain under cross-examination. Never use the words, questions starting with how, what, when, where, describe, explain. That's for leading in chief. You don't do that in cross. And there's the rule. Think of the answer, then put the answer in the witness's mouth. Okay? You want the witness to say they were driving at 60 kilometers, they were exceeding 60 kilometers an hour. You don't say to the witness, what was your speed? That's not a leading question. The witness will give you a speed that suits them. You will say, you were driving at night. Yes. You were concentrating on the road. Yes. You did not look at your speedometer. No. You were not sure of your speed. Yes. You see, that's how it works. Now, these are the things you must not do under cross-examination because it undermines your case. Never be vexatious, abusive, oppressive, and discourteous. Avoid sarcasm and rudeness. You will turn the judge against you. Aggressive cross-examination is not the most effective cross-examination. Okay, go and listen to the really good lawyers cross-examine. They are not aggressive, okay? You must never mislead a witness. Don't ask questions that are calculated to mislead the witness. Judge will stop you, and you might even be reported for unethical conduct. Don't ask questions that are irrelevant. They must be relevant to the issues. And the one excuse that lawyers use is that they ask a question that's irrelevant, and the judge says, what's the relevance? They get away by saying, well, it's relevant to credibility, my lord. You will get away with it, but don't make a habit of it. You are allowed to repeat questions to test the witness, but this has a limit. Presiding officers will stop you and say, look, you asked and answered, just stop it now. A cross-examiner is not allowed to elicit inadmissible evidence in his own favor. And a witness cannot be cross-examined on a privileged statement. So don't try and sneak that in. If you ask questions about a collateral issue, the answer is final. That's a rule of cross-examination. It's a rule of evidence. The reason being that if an answer to a collateral issue is not final, it simply opens up the case. Other witnesses are called, more cross-examination, more witnesses, and it'll never end. So we don't allow it. Be careful about what you ask. If you elicit unfavorable evidence in a legitimate answer to your question, it's admissible against you. You can't object. This is a trap that many lawyers fall into. How do you avoid it? Stick to asking only leading questions. Okay. And here are some final suggestions. Cross-examine only if the evidence is adverse to your case. Do not cross-examine if it is not necessary. Know what you want. You must always arrange your cross-examination fact by fact. This long, rambling cross-examination that has no particular direction doesn't work, okay? When judges have a way of telling you that you're not getting anywhere, you should sit down. Some judges will actually say, Mr. Smith, I think you should sit down. But, these days, post-Constitution, judges are concerned about giving you a fair trial or your client a fair trial. So they won't tell you to sit down like they did in the good old days when I was a young advocate. Now the judge will say something like this. You are droning on and on. The judge will look up and say, Mr. Smith, do you think you'll be finished by the tea adjournment? Now you know. When a judge asks that question, it means he was not listening to you in the first place. He's saying to you, I've heard enough of you, just sit down now. Okay. Or if the judge says, do you think you'll be finished by lunchtime, Mr. Smith? Well, that's not a question you want to hear. Then here's a big mistake as well. Getting concessions from witnesses that they will not make. For example, I gave you a demonstration where you got the witness to say that they didn't notice the speedometer. So the witness says, you say, so you were not looking at your speedometer? No. Now that's what you want. But now you want the concession, so you make the mistake. You'll say, in that case, you don't know what speed you are doing. No, not exactly, but I was going slowly. You were going too fast. Oh no, I could never have been going too fast. Do you see? You will never get that concession. That's argument. You get the facts you want, then you comment and you make argument, okay? You must reserve your conclusions and comment for final argument. Never expect a witness to agree with you because they will not, okay? How you lead in chief and cross-examine actually determines whether you persuade the judge, okay? You get your leading and cross-examination wrong, you're going to lose the case. All right, it's 4 o'clock. What's left is expert witnesses. I've written this up for you. I dealt with a fair bit of it during the course of this. I can't deal with it now. Betty, are there any questions?
None, sir.
Okay. All right. So we're finishing on time then. We can't go on because we're going to get cut off. So I would there's the final argument. Read what I say about argument. Things like keep it clear, keep it short, relevant, logic. Those are the things. And most of all, I told you this when we started, I'm telling you when we're finishing. Everything you do must have reasoning. You must be able to show that you applied your mind. Whatever you tell the judge means that you've reasoned it. And that's what you write in your heads of argument. You don't copy and paste from anywhere. Your own reasoning, your conclusions supported by your own reasoning must appear. Okay? And finally, what I want to say to you is that the most important attribute or skill for a trial lawyer is to be literate. You must have strong literacy skills. That's where you get the ability to reason on your feet. You know, one of the hardest things to do as a trial lawyer is that you might appear before a judge who fires questions at you that you were not expecting, you did not prepare. You have to think on your feet. So what gives you those skills? Good, powerful literacy skills. For that, you have to read a lot. Read lots of books, any kind of book, but read at least one book a month. If you don't read a lot, you are not going to improve your literacy skills. You are not going to be a good trial lawyer. That's it. Okay? Go and open a Chisamnyama somewhere. If you don't have literacy skills, stay out of a courtroom. Okay? One book a month. It's actually in the norms and standards published by the Legal Practice Council. If you didn't see it, it's published in the Government Gazette, or you can Google norms and standards, go and read it there. Read one book a month. That's the secret of your success. By the way, and I'm going to conclude with this, I told you We are overrun with lawyers. We can't cope with the number of LLBs that are coming out. But there's a severe shortage of good lawyers. And there's a severe shortage of good trial lawyers. If you apply yourself and you get good at trials, you will be seriously successful and you will do really well. You will not need a tender to buy a Range Rover. You'll afford it for yourself. Okay. All right. Thank you for attending, and good luck with your careers.